On February 24, 2026, a compliance hearing convened in the 47th District Court of Potter County, Texas, presided over by Judge Baker. The case, Department of Family and Protective Services v. Brianna Monday and Anthony Dilworth, involves two young children, Noah and Waylon, who were removed from their parents' care due to substance abuse and domestic violence concerns. Since the last hearing, the parents have separated. Mother Brianna Monday remains in Claude, Texas, showing significant progress with negative drug screens and improved stability, while Father Anthony Dilworth has relocated to the Weatherford area with admitted ongoing alcohol and marijuana use and no completed drug testing.
I will go ahead and call cause number 100111-2. This is the department versus Brianna Monday and Anthony Dilworth. We're here for a compliance hearing on a court-ordered service case. We are conducting this through Zoom. We are live streaming, and Ms. Galvan's making our record this morning. All right, we'll go ahead and take announcements.
Morning, Your Honor, Counsel Gene Graff and Katrina Sledge on behalf of the department, present and ready.
Natalie Archer for the mother, Brianna Monday.
Vince Nowak for Anthony Dilworth. We're both here and ready, Judge.
Stacy Zavala on behalf of the boys.
All right, then, Ms. Sledge, are you going to give us the update?
Yes, ma'am.
Okay, raise your right hand for me. You solemnly swear or affirm the testimony you'll give today will be the truth.
Yes, ma'am.
All right, then. You can go ahead and update us, and we'll see who's got questions.
All right, so everybody is doing great for the most part. Since our last hearing, Brianna and Anthony have decided to separate. Brianna is in Claude with her support of her family, her brother. Anthony has moved to Hudson Oak, Weatherford, Texas, down there in that area. This happened back in January. At our last hearing, they have completed everything except for substance education and then the random drug testing, alcohol testing, as well as Brianna to continue to engage in the WAVE program. As far as Anthony, he has completed his substance education and parenting, did really well through that. However, he has not completed drug testing for us. I did get a courtesy worker out there who did the education with him, and he did a great job through it. But he did admit recently, the last update in February, to ongoing alcohol and marijuana usage. But again, we don't have any tests for him. Brianna has completed her substance abuse and education as well as some parenting. As far as the WAVE, she doesn't have transportation. She's residing in Claude. She doesn't have anything consistent. And with WAVE, she has to be there every Tuesday from 12 to 2 on time every week, or she would get kicked out.
The caseworker testified under oath about the parents' divergent progress since their separation. Brianna Monday has completed substance abuse education, parenting classes, relationship education, and provided clean drug screens, negative for marijuana since April 2025, and alcohol since January 2026. Anthony Dilworth, however, has relocated to another city, completed education but refused drug testing, and admitted to ongoing substance use under Section 263.306 of the Texas Family Code. Compliance hearings in child protection cases require the court to review whether parents have substantially complied with their court-ordered service plans and whether return of the child would be safe. The statute mandates that the department provide the court with a detailed report on each parent's progress, including completion of services, substance testing results, and visitation patterns. Additionally, Section 263.307 requires the court to determine whether continued placement of the child outside the home is necessary, weighing the parent's progress against the child's need for permanency and stability. Judge Baker is conducting exactly the type of individualized assessment Section 263.306 envisions, comparing Brianna's documented compliance, clean screens, completed services, employment, improved relationship with caregivers against Anthony's non-compliance, admitted ongoing use, refusal to test, geographic distance creating barriers to visitation. The court's decision to continue the case rather than dismiss reflects the statutory requirement that parents demonstrate not merely partial completion, but sustained behavioral change that ensures child safety. The caseworker's testimony about Brianna's transportation barriers and Anthony's admitted substance use provides the factual foundation for the court's continued jurisdiction. Texas law recognizes that child protection compliance hearings serve as critical gatekeeping moments. Courts must balance parental rights against child safety, and premature case closure can result in re-entry into foster care if relapse occurs. The statute's emphasis on substantial compliance, rather than mere box checking, protects children from being returned to environments where substance abuse persists, but has been temporarily hidden from view.
So they also sent me some resources for virtual wave for her through Family Support Services, but none of those were contracted with us because they don't have a physical office. So what we did was do some relationship education in home, and she has completed that as well. Brianna has also completed drug testing for me as requested, and she has been negative for any marijuana since April of last year, and she has been negative for any alcohol since the end of January. She's thriving and doing well. She has a job. She's fixing to start a job. She did have some struggles getting a job because of that charge and Claude being so small, but she's finally got a job, she reported, and she's doing great. Anthony also, from my understanding, has a job that he's working as well. The kids are doing great. So that's parents on the update on the parents. Kids are doing amazing, thriving. They're up to date on well child checks. They're both just developmental wise doing great. Noah's receiving some services through Green Apple Therapy, speech and occupational physical, and he has made tremendous progress there. Waylon is crawling, and they're just doing great. Kids are doing great. Grandparents have been amazing with the kids, making sure they're up to date on well child checks and immunizations. They have had a lot of medical stuff here lately, the kids have, but those grandparents have been amazing to assure that those are, being taken care of and addressed, and communicating with the parents. One of the issues we had last time was a visitation. That was a big thing that we talked about because the parents weren't having visits. Since then, Anthony, because of the move, he hasn't had any contact with the kids, but Brianna, her relationship with the grandparents since that split has improved tremendously. She's there at least once or twice a week, anytime they need something. Of course, she is making sure they have it. And we just recently updated the safety plan to allow her to have the kids on the weekend. She was being supervised, but me and my supervisor did talk yesterday, and we were going to start lifting that safety plan for her because she has been negative and she's doing well. I know she has talked with the grandparents. That's something her and the grandparents have talked about. And because they're doing so good, and that's where stability is for them, and she doesn't have a vehicle, she doesn't want to necessarily just pull them from the grandparents or anything like that, because that is where stability's at. And she knows she doesn't have the transportation to get them back and forth here, Amarillo, medical appointments and stuff like that. So I think since the split, she's thinking more level mind, more mature, focusing on self. And Anthony's doing the same. He just hasn't had any contact because he's not here. So
Have we attempted to do any kind of virtual just so he can see the kids?
I have not. I have not. I think there's still some issues with, and I don't think it's the grandparents. I'm not too sure, Judge. Honestly, I know there's still that hostility with him and the grandparents. And I don't know, I don't necessarily think it's on the grandparents' part. I know he still has some struggles there. So I don't know.
Is there anybody else that could just be there, for a short, they're so young.
Yeah.
We're talking about something that's going to take 10, 15 minutes,
Mhm.
once or twice a week because, they're just so little that they're
Yeah.
not going to interact much, but it's just an opportunity for Mr. Dilworth to get to see the kids, see that they're doing well.
Yeah.
He can see how, Waylon is progressing with crawling and, that kind of,
Yes.
so it's not like there's even going to be like a ton of dialogue probably between them, but can we
Yeah.
figure out
Judge Baker proactively initiated discussion about establishing virtual visitation for Anthony Dilworth, who has had no contact with his children since relocating. The caseworker revealed ongoing hostility between Anthony and the maternal grandparents who are caring for the children, complicating visitation arrangements despite the grandmother's willingness to facilitate contact. Under Section 153.015 of the Texas Family Code, courts are explicitly authorized to order electronic communication, including video calls as a supplement to physical possession, requiring only that the communication be reasonable in duration and subject to the same restrictions as in-person visitation when necessary for child safety. The 2015 amendments to this provision reflect legislative recognition that technology can preserve parent-child bonds when geography or safety concerns make physical visitation impractical. Additionally, Section 263.107 mandates that the department and courts promote frequent and continuing contact between parents and children in foster care, unless such contact would endanger the child's physical health or emotional welfare. Judge Baker's intervention demonstrates the court's affirmative duty under Section 263.107 to ensure continuing contact even when logistical barriers exist. The judge specifically tailored the proposal to the children's developmental realities, acknowledging that infants Waylon and Noah will have limited interactive capacity while emphasizing the importance of Anthony witnessing their developmental milestones. The court's rejection of the hostility explanation as a barrier and its search for an alternative supervisor, the grandmother rather than the grandfather, reflects the statutory preference for preserving parental relationships through creative problem-solving rather than allowing interpersonal conflict to sever bonds. Virtual visitation provisions prevent the common child welfare tragedy, where parental relocation or placement disruption results in complete relationship dissolution, leading to termination of parental rights based on failure to maintain contact that was structurally impossible rather than intentionally abandoned. By ordering the department to facilitate electronic communication, Judge Baker ensures that Anthony's progress or lack thereof will be measured against his actual opportunity to parent, not against a standard made impossible by circumstances beyond his control.
Yes, ma'am. Yes,
Someone to
ma'am.
maybe handle that where there's not the friction.
Yes, ma'am. I think a lot of it's he doesn't have the problems. The relationship is more altered and tainted between his grandfather and him, not his grandmother. So she's pretty big. Grandmother's been the more communicatable one with Anthony. So I think she will be able to do that to get those visits in. I do believe he does call because he lives with his mom. So that's grandma's daughter. So she is communicating with them some.
So, Mr. Dilworth, is that something you're interested in doing? Is just getting to like be able to see him on FaceTime or some kind of virtual format? And you'll have to unmute, sir. I don't know, his video went. Okay, Mr. Dilworth, can you hear me?
Judge, in talking to Anthony, I do believe that's something he would look forward to.
Okay.
I'm not sure. I'm not sure why he went dark, and there he is. There he is.
Yeah, we're having a little, and I don't know if Mr. Dilworth, can you unmute? I'm sending you. Okay, we can't hear you, so I don't know what's going on with your audio. But
yes, ma'am. Can you hear me?
Oh, now I can. Yeah. Okay. So, is this something that you would want to do?
I was just gonna say.
Okay, you're breaking up. Let's try this, Mr. Dilworth. Try turning your video off.
Is any way that you could possibly repeat that?
Okay, so are you interested in having? You can leave your video off. That might help this breaking up thing we're having. Are you interested in having some kind of, virtual visitation with the kids where you can see them and see what they're doing and that kind of thing?
Yes, ma'am. Absolutely.
Okay. So Miss Sledge will go to work on seeing what we can do. Now, whoever is going to be the adult running that operation, meaning who's going to make the phone call and operate the phone and, all that, you're not going to have a problem with them, are you?
No, ma'am. I personally don't hold any grudges towards anybody at this moment in time.
Okay. Are you going to hold a grudge next week?
No, ma'am. No, ma'am.
Okay.
I'm
right.
okay.
Okay. Just, the time is for you to spend seeing your kiddos, you can try to talk with them, but there's so little, it's hard. So,
Yes, ma'am.
especially with Waylon, but that at least it'd give you a chance to get to see him and everything. So, okay.
Yes, ma'am.
And it gives them the opportunity to hear that dad is calling to check in on them. So,
Absolutely. Yes, ma'am.
regardless of their age, that's important. Okay, then, Ms. Sledge, anything else with respect to the kiddos?
No, ma'am.
Okay. Okay, Mr. Nowak, you got any questions?
Well, Judge, you took my thunder on the visitation. Thank you for that.
So sorry.
And Katrina, it's always great to see your smiling face, and thanks as always for taking my phone calls. And it sounds like Anthony is in compliance with everything except we need a clean screen, correct?
Yes.
All right, well, you and I are going to work with young Anthony on that.
Yeah.
Judge, that's all I have. Katrina, thank you so much. I'll pass the witness.
Do we have a lab down there contracted that we can get him to?
Yes, sir. Yes, ma'am. I'm sorry. We did, when the worker went out, the courtesy worker went out, she did ask him to go. He just didn't go. So, and I don't know if it was work. I don't know, but he just hasn't gone yet. But she has sent that twice, and he just hasn't gone yet. So,
Okay. So, Mr. Dilworth, I'm just going to tell you straight up, we got to make that happen, or we just can't move forward with your case, with you. So, we're going to try to get it set up, and you need to go. You need to do it, even if it's going to be positive. Do it for us so we can then monitor to see if levels are going down. It's just I'll let your lawyer explain it to you, but we can't move forward with you until we get that. Then Ms. Archer, did we lose her? Nope, she's there. Can't hear you though. No, ma'am. Okay, shows you're connected to audio now. All right, Natalie, you're breaking up real bad. Maybe try turning the video off.
Is that better?
Yes, significantly.
Okay.
Judge Baker delivered a direct ultimatum to Anthony Dilworth. Without drug testing, his case cannot progress regardless of other completed services. The caseworker revealed that testing had been arranged through a courtesy worker, but Anthony simply failed to appear, twice. The judge explicitly acknowledged that a positive test would not end progress. It would establish a baseline for monitoring reduction. Section 261.303 of the Texas Family Code requires the department to develop service plans that include specific and measurable objectives for parents, with substance abuse testing serving as an objective verification tool rather than punitive measure. The 2018 Texas Supreme Court decision in re al. established that courts may not condition family reunification on perfect compliance, but must assess whether parents have made meaningful progress toward addressing the conditions that led to removal. However, in re al distinguished between minor procedural lapses and fundamental failures, ongoing substance use without verification falls into the latter category because it directly implicates child safety. Judge Baker's statement that even if it's going to be positive, do it for us so we can then monitor to see if levels are going down, operationalizes the AL principle. The court seeks evidence of behavioral trajectory, not immediate perfection. Anthony's refusal to test deprives the court of any objective measure to apply this standard. The judge's framing transforms testing from a pass-fail hurdle into a diagnostic tool consistent with Section 261.303's rehabilitative purpose, while maintaining that complete refusal to participate constitutes non-compliance that blocks case progression. Parents in child protection cases frequently misunderstand testing requirements as traps designed to catch them using rather than tools to document recovery. Judge Baker's explicit explanation that positive tests can be worked with, but refusal cannot addresses this misconception directly, potentially preserving Anthony's opportunity for reunification by clarifying that transparency, even about relapse, serves his interests better than avoidance. This judicial communication strategy reduces the perverse incentive to hide substance use rather than address it.
Miss Sledge, I was just curious about Brianna having to test for alcohol.
Mhm.
I don't recall any incidents of her drinking around the kids. Why is she having to still do that?
So back in December, they had an incident. Her and Anthony had an incident that resulted in her arrest. That was the arrest for assault.
Right.
And when I talked to them, she indicated that alcohol played a factor in that. And so that's why we started alcohol testing. She did admit to me at that point that she had stopped using marijuana, but had kind of started picking up drinking alcohol, and alcohol was a factor in it for both of them. So that's why we added the alcohol test.
Okay, I was just curious. I don't think Brianna minds doing that. I was just wondering. Um, and you don't have any trouble getting hold of the parents, do you?
No, no. Brianna is very she has struggled with both of them finance wise and keeping the phone, but they find a way to get a hold of me, even if it's a text now number or whatever. They do real well with staying in contact with me.
And generally, you think things are moving in the right direction with Brianna?
Yes, ma'am.
Okay, wonderful. I'll pass the witness.
Okay, Ms. Zavala,
I have no questions, just a report if you're ready for that.
I'm ready.
Okay, I got to see the boys and grandparents home on Friday. I think that Brianna was on the way to come get them. The boys are doing really great. And grandparents were very complimentary of Brianna and how they're all working together as a team now. And it just seemed like a very good situation. And I was thrilled to hear that. Grandparents did seem to think that the case was closing today. I don't know if that's the situation. But the boys looked very good, and I'm glad to see visitation with mom back on track, and everything that I was hearing about that was very good.
Okay, I don't think we're quite there yet at the point of closing. I think we still got some things to do, obviously. So I would like to, give this another round and get back together June 2nd of 2026 on a 9 o'clock docket. Unless parents are done with everything and we don't have any concerns, and then the department is certainly free to dismiss, before that date. But I think we need a little more time to just make sure that we got parents pretty soundly on their feet. And I since they have split, I'm going to toss it out.
The children's attorney, Stacy Zabala, reported positive observations from her home visit, noting the grandparents' praise for Brianna's cooperation and the children's strong developmental progress. However, she disclosed the grandparents' misconception that the case would close today. Judge Baker responded by continuing the case to June 2, 2026, explicitly rejecting premature closure despite Brianna's substantial progress. Section 263.401 of the Texas Family Code establishes a 12-month deadline for final orders in child protection cases, with limited extensions, reflecting legislative intent to provide children permanency without indefinite foster care. However, Section 263.403 requires that dismissal of the department's managing conservatorship be supported by a preponderance of the evidence that the parent can provide a safe environment, with courts specifically directed to consider the stability of the child's living arrangement and the parent's ability to meet the child's immediate and long-term needs. The 2019 amendments to Section 263.403 added explicit consideration of whether parents have developed support systems to prevent future crises. Judge Baker's decision to continue rather than dismiss reflects careful application of Section 263.403's safety-focused standard, rather than the 12-month deadline's procedural pressure. The judge specifically identified the parents' recent separation as a complicating factor, requiring monitoring, recognizing that relational instability can trigger relapse even when individual progress appears strong. By setting a future date while inviting earlier dismissal if concerns resolve, the court balances statutory efficiency mandates against the reality that Brianna's new employment, transportation limitations, and changed living situation need time to demonstrate sustainability. The grandparents' misconception about closure timing suggests the family may not fully appreciate the legal standards still to be met. Child protection cases often fail at the finish line when courts dismiss based on short-term compliance that collapses under stress. Judge Baker's caution honors the statutory preference for stable reunification over rapid closure, protecting both children from re-traumatizing re-entry into care and parents from having their progress undermined by insufficient support systems. The continued jurisdiction preserves court oversight during the critical early period of Brianna's independent parenting, when relapse risk remains highest.
I'm not trying to heap on, but do we need some co-parenting, with each of them?
I had thought about doing some co-parenting education for them, just because like Brandon, she's done with everything, but I also know that there's some we can provide that education for her and him. There's different websites from the attorney generals where it's setting up things if they can't communicate, that they have that app to communicate so that it's not a volatile situation anyway, whatever works for them. Of course, we want to set them up so that when we're not involved, they can still do this effectively without issue. So,
Okay. I would really like to see that happen, just so that they're aware, people that haven't been through this may not be aware of some of these very sophisticated apps that are out there for scheduling and putting in communications and all that. And they're very, I think those have been very successful, and they're a really good tool. So let's just try to, let's do a little education and make aware about what there is, and that might help them moving forward. So, because Mom, Dad, once we're out, then it's up to you guys to try to get along and communicate. And, in a nutshell, if you guys don't communicate effectively, when these kids are like, 16 and 13, well, good luck to you.
yeah.
Because you're going to have a lot on your hands. So, children will manipulate. It's just the way it is. And if you guys aren't talking and you're not on the same page, then, they're going to just run right over you guys. And not because they're bad kids, just because they're kids. And that's what they will do. So better for you guys to learn how to just get along for the sake of the kids, and, talk about things right now. And life will be so much easier for y'all.
Great.
Okay, then I'm going to continue our services. I'm going to find parents are in compliance with their family plans of service, but we do need Mr. Dilworth to drug screen for him. I'm going to order that, Miss Sledge, so we can get that set up. I don't know whether Mr. Dilworth, that can be done today. I'll let Miss Sledge contact you and tell you where you need to go, and I'd certainly like to see that happen by noon tomorrow.
Yeah. Judge Anthony started a new job. I think he started it today, and he's using his lunch hour to be here right now.
Okay.
So, Anthony, can you get it done by noon tomorrow? Maybe 4 tomorrow?
I can probably do around 4 o'clock, yes.
By 4 tomorrow?
Yes.
Judge Baker concluded the compliance hearing by ordering continued co-parenting education and requiring Mr. Dilworth to complete a drug screen by 4 p.m. the following day, with flexibility for his new employment schedule. The court set the next hearing for June 2026. Under Section 26306 of the Texas Family Code, courts must review family service plans at each hearing and determine whether parents have substantially complied with requirements. Section 263.307 mandates that courts order parents to participate in services addressing the specific factors that led to removal, including substance abuse treatment when indicated. The court's authority to modify deadlines and accommodate employment obligations derives from Section 263.103, which grants judges discretion to tailor orders to individual circumstances while maintaining case progression. In re al. 2018, the Texas Supreme Court emphasized that procedural flexibility must serve the child's best interest without undermining accountability. Judge Baker applied these provisions by acknowledging Mr. Dilworth's compliance with most service requirements while imposing the critical outstanding obligation of drug screening. The 4 p.m. deadline with built-in flexibility for work scheduling demonstrates how courts balance accountability with economic stability, recognizing that maintaining employment directly supports reunification. The co-parenting education order addresses Section 263.307's mandate for services targeting the specific risks in this case, parental conflict and communication breakdown that could re-traumatize the children post-reunification. This exchange illustrates how compliance hearings function as precision instruments rather than binary pass-fail evaluations. Courts that rigidly enforce deadlines without regard to employment realities risk destabilizing the very families they seek to reunify. Conversely, complete flexibility without accountability enables non-compliance. Judge Baker's calibrated approach, extending the deadline while explicitly warning, "You don't have just forever and ever," models the statutory balance between support and accountability that research shows produces more durable reunifications. Judge Baker continued the case with services maintained and set the next hearing for June 2026. The court found both parents in compliance with their family service plans overall, but ordered Mr. Dilworth to complete drug screening by 4 p.m. the following day with flexibility to coordinate through Ms. Sledge if work scheduling required adjustment. Co-parenting education was ordered for both parents, including training on communication applications and scheduling tools. No bond was required, and both parents remained in non-custodial status with ongoing virtual visitation. The attorney for Mr. Dilworth was granted a post-hearing breakout room to consult with her client. This case exemplifies how modern dependency courts have evolved from adversarial termination proceedings toward collaborative family preservation systems. The statutory framework under Subchapter D of Chapter 263, requiring individualized service plans, regular compliance review, and graduated responses to progress, reflects a fundamental reconceptualization of state intervention in families. Rather than viewing parents as obstacles to child safety, the law now treats them as partners whose success requires tailored support. This shift carries constitutional weight. The Supreme Court in Santosky v. Kramer, 1982, recognized parents' fundamental liberty interest in family integrity, and Texas's compliance-based approach honors that right by exhausting preservation efforts before considering termination. For viewers, this case demonstrates that effective child welfare law is not about winning or losing. It's about building systems that help families succeed. If you found this case illuminating, explore our earlier coverage of the In Re AL decision and its impact on Texas family law, or watch our deep dive on Section 263.401 permanency deadlines. Subscribe for weekly educational court content and share your questions about co-parenting orders and compliance hearings in the comments below. Thank you for learning with us today.